Hello, good afternoon, Chia. I can't hear you. You're muted.
Hi, Sarah. How are you?
I'm good, Chia. I'm good. I should draw the curtain.
You are still very fresh.
Thank you.
I still eager to give this talk. Good.
I see everyone. Our friends are joining the call and the webinar now. Good afternoon,
Sulip.
Dancing. Thank you for joining us this afternoon.
Yeah, Sulip is our regular members here. Okay.
We got another minute to go, then we will start. I'm told, Chia, that this is a very exciting topic because not every day there is a seminar on stamp duty. And I think this is the first seminar of its kind where there is a discussion on valuation,
Yeah, that's right. In fact, very interestingly, I think yesterday, I was chatting with some lawyers in Penang, and they actually asked about this issue concerning the stamp duty and the valuation by the stamp office, how to challenge it, that kind of thing.
Right.
And in fact, one of the lawyers in Penang was telling me that they've done about 3 or 4 challenges. Only one is successful. Most of the time, it's not successful at all.
Right.
So I think this is very timely as to what so-called evaluation made by the stamp office and how to challenge it and what are the criteria to challenge it. Yeah. So yes. Do you want to start? It's 2:30.
I see numbers are still being signing in. And if you just give them 1 more minute.
Yeah,
because we have about 800 plus people have signed up.
Yeah.
So that's why I guess they all are signing in as soon as they can. But another 1-2 minutes, we'll start. The topic is purely discussing how the valuation of land office can be challenged, isn't it?
Yeah, that's right. I see my old friend from Penang is here, Dr. Brian Tan. I think he's your old friend as well.
Oh, yes. Hello, Dr.
We cannot respond.
Strong man from Penang.
Yeah, that's right. So true. I can see some familiar names here.
Okay, Chia, I think we should get started. Let's get started.
Okay, just to everybody here, a very good afternoon. I think we have very positive response. As Sarah said, we got more than 800 people who have registered, and especially this Thursday afternoon. I think most of you will know who Sarah is, and I think you have seen me and Sarah in this kind of webinar over the last few weeks. But anyway, for those of you who may not know us and just joining us, just to let you know that our speaker here, Mr. Saravana, is a partner in Rosty Dana Saravana, and he's our partner in charge of a tax practice, a very prominent tax lawyer, and he has represented many clients, including already listed company in many tax disputes with the authority, and has been awarded as one of the top 100 lawyers in Malaysia by many organizations, including Asia Business Law journals. I myself, again, very shortly, my name is LT Chia. I'm also a partner of RTS, but based in the Penang office of RTS. So for those of you, I see some very familiar names here. Some of them are from Penang. But nice to know that you are joining this webinar. But anyway, for those who are not from Penang, if you have any issues, any problem relating to matters in Penang, just give us a call and we'll be able to provide our service to you. So without much ado, let us start the seminar. And today's topic concerns the issue about valuation and stamp duty. I think we all will know that each time you buy a piece of property, it's subject to stamp duty based on a certain valuation. And the law is very clear that the amount of stamp duty is based on the purchase price as stated in the sale and purchase agreement or the market price, whichever is the higher. So Sarah will share with you cases where the stamp office have invoked the principle of market price and assess the stamp duty much higher than what was stated in the sale and purchase agreement. In other words, much higher than what was within the contemplation of the parties in the sale and purchase agreement. So this one topic that Sarah will touch on today and share with you some recent cases that he has undertaken in Johor Bahru. The second issues relate to the what we call the adjustment by the IRB under Section 140. I think some of you are familiar with that. Some people call it the arm's length dealings under Section 140 of the Income Tax Act. And the issues that Sarah will share with you is how to challenge the what we call the adjustment made by the IRB, and whether there is a need for IRB to give reasons when they made such adjustment. And Sarah will go through with you again recent cases on this point, and the whole session will last until 3:45. But we will definitely have enough time for you all to ask question and answers. And anyway, in this webinar, there is an icon for you to click on for the Q&A, where you can type in your questions. We'll try our best to answer your questions. And if not, then we will probably answer it through emails and all this. So without much ado, Sarah, go ahead and share with us your experiences and what you have seen in court.
Thank you, Chia. Thank you, friends. Once again, thank you for joining us. I will start by sharing a screen. Afika, you have to allow me to share the screen.
Okay, hold on, sir.
It says it's being disabled.
There you go, sir.
Thank you very much. Okay. Chia, can you see the slide?
Yes, I can, and the audience can see as well.
Okay, good.
Okay, good.
Everybody can see the slide. So the first case I want to discuss is questions to ask. Is the JPPH value? If you're wondering, what is JPPH is Jabatan Penilaian dan Penilaian. I don't know what the other. I can't remember the P now. Penilaian Harta, which is a division under the Ministry of Finance. Whether their valuation is final and conclusive. Because in tax matters, the IRB seems to take the view that once JPPH gives you the valuation, that is the finality. You got to accept it. It cannot be challenged. Of course, we know it's not true. Otherwise, matters have not gone to court. JPPH valuation can be challenged and has been challenged in many occasions, not only for tax and stamp duty purposes, but also for land acquisition purposes. Because land valuation is essentially a subjective exercise, looking at various factors, and the factors are then made into adjustments either upwards or downwards. But to say that the JPPH valuation is the final and the only correct valuation is not right. And the reason I'm generally given is because it's the government's valuation, therefore it is right. I think gone are the days of the principle that the government is always right. I think it's good if the revenue also embraces the philosophy that they're not always right. They're also wrong sometimes, in fact, most times. Next, I want to discuss in the presentation today, what are the factors to consider when engaging a valuer? What are the factors to consider when you engage a valuer? And finally, how do you then challenge a valuation prepared by JPPH? I will come back to this slide at the end of my presentation to sum up on what I have, presented. And I think the best way to make a presentation is to look at case law. So the two cases, which are very recent cases that Nava and I handled in court. The first case is the case of Parkwood Palms, which is a very recent decision from the Johor Bahru High Court, a stamp duty case. And the second case is the case of Rainforest Heights, which is a decision from the Court of Appeal. Both are very recent decisions. For Parkwood, the revenue, of course, have appealed to the Court of Appeal. Taxpayer entered into an SPA to buy a piece of land. The land was located at the fringe of the Johor Bahru Central Business District. Across the road is the CBD district. We are the fringe. Taxpayer, the developer, they bought the land for development purposes. Large piece of land. They bought land for about 54 million ringgit. The taxpayer sent the land, the MOT for stamping. The IRB took the view that the land value is higher than the 54 million ringgit that the taxpayer paid to the third party. And bear in mind, the third party from which our client bought this land from is a listed company. Yeah, Chia, that makes a difference, isn't it? A listed company cannot be selling a land which is worth $10 for $5.
Exactly. They have also certain what they call standard to adhere
standard.
To.
There will be scrutiny. Their shareholders look at it and so on. But that was irrelevant for the IRB or the stamp office, which is part of IRB. The collector of stamp duty said, no. The value is much higher. And he decided to go and ask JPPH for valuation. And the JPPH gave a valuation for 110 million ringgit. Okay. So client said, this is ridiculous valuation. Nobody buys this land for 110 million ringgit. But the stamp office and the land valuer said, no, the land is worth 110 million ringgit. If the stamp officer was not the civil servant, I would have asked him to buy the land for 110. Since you say land is worth 110, I give you discount to buy for 100 million. Then you sell it for 110 and make a 10 million ringgit profit. Why do I say this? To give you an idea. Yeah. Next to this land, about 300 to 500 meters away, is the Hokkien funeral parlor. Okay. Next, behind the land is the Catholic cemetery. A bit away is a Chinese cemetery. So not talking about one, you're talking about the funeral parlor on the same row, walking distance. Behind Catholic cemetery, not too far from the Catholic cemetery, a Chinese cemetery. Okay. If this is not enough, there is an abandoned shopping mall there. A huge mall which is an eyesore. For the last 2 years, it is not in operation. It's abandoned. And on the adjacent land is a low-cost apartment called Saujana Apartments that have been constructed. So giving these reasons, do you think the land is worth 110 million ringgit? But for the officer, he said, yes, it's worth 110 million ringgit because he said the JDV of the land, the project JDV was 450 million ringgit. Therefore, he said the land is worth 110 million ringgit. Taxpayer explained, listen, I can still build a house in this area, a condominium, but this condominium won't fetch much in value. It's a very high density condominium. It is targeted to people who are not so discerning. You know, you want a home and you don't mind staying next to a funeral parlor or a cemetery. Open your balcony in the morning, you see cemetery. You know, I don't know how many of your listeners today have your view as a cemetery when you open your window. And I don't know whether you want to stay in such a location. But the developer said, I'm a developer, there will be a market for that kind of situation. But the question here is not what is the value of the project. The question here is what is the value of the land at the time of transaction. You cannot determine the value of the land based on its future development potentials for stamp duty purposes. Transaction price is 54 million ringgit, which JPPH valued at 110 million ringgit. So we called two valuers, two independent valuers to justify. They all are well qualified valuers from Johor Bahru, very seasoned in going to court. One valued at 54 million, one valued at 56 million. Okay, so the two of them gave different values, but 56 million, my client said I can still accept and prepared to pay duty on 56 million, but not 110 million. So first they say walking distance to cemetery and crematorium. Okay, Chia, I don't know about Penang. Penang also got shortage of land, but I don't know whether you can, you know, there's a demand to stay next to a crematorium and cemetery.
Yes, there is. But the demand not so high because those are more not what they call the high end.
Yes.
Not the high end.
So the question here is, Chia, I want to ask you, because you do a lot of conveyancing and corporate work, would you regard this land as prime land?
I mean, with that kind of cemetery, especially a big size and so many, really, you know, it's not something that can go high end. So
Yeah.
it cannot be prime as well, no?
But the stamp office called this prime land.
Is it?
Okay. So the prime land is next to crematorium and cemetery. Then the land is within walking distance to low cost, medium cost apartment and a shopping mall which has ceased operation. And of course, a sluggish market condition in 2018. All these factors were ignored by the JPPH valuation officer in his report. And when he testified in court, he also didn't touch on all this.
I see.
What he was focusing on was, in court, the land is nearby Central Business District. He said it's next to nearby Pan Pacific Hotel, nearby the Pesada, Johor Convention Center, nearby, you know what, the immigration center, what do you call that? CIQ, the CIQ center. So in his evidence in court before judge, he gave how great the location is. So I listened to him quietly, took his own map. He was showing judge how near the land is to all these areas. But he didn't say nearby my driving, not walking, all were driving. He didn't talk about that. What I did, Chia, in court, I took the same map. I plotted the cemetery,
Okay.
the funeral parlor and the abandoned mall and the Rumah Murah apartment. On his own map, I plotted it in red and I showed it to him during cross-examination. I said, officer, you were very eager just now to assist court by showing judge all his locations. Thank you very much. How long does it take to go from here to Pesada? Oh, it takes about 10 to 15 minutes. Walking? No, you have to drive. Can you walk? No, I can't walk, he said. Sure, I can't walk? No, the road is not meant for walking. Can I just ask you, where is this funeral parlor? It's nearby. How near? He said, nearby lah. Okay, nearby means walking distance? He said, oh, it all depends. What do you mean by walking distance? I said, okay, 300 meters. Do you call it walking distance? He said, yes. Okay, so is this within 300 meters? He said, yeah, about there. Okay. So then I asked him about the mall. I asked him about the parlor and the cemetery, crematorium and the Rumah Murah apartments. All he said walking distance. That's why I put here walking distance. So I asked him, in your report and evidence before judge, you have taken the trouble to explain all these other attractive areas, which are all far away from my client's land. Or what is within walking distance, you have conveniently forgotten to include that in your report and your witness statement. Is that so? He had no answer. Because I reminded him, he's an expert witness. As an expert witness, he is in court not to take sides, to tell the truth to judge, so that the judge can make an informed decision. Luckily, I ronda and Johor Bahru very often. I know all these locations, you know. Imagine if I don't know this location of all these areas, he would have gotten away to court by not telling the court the whole truth. So this is what you must look for in the JPPH report. First thing, all the adverse factors. On the other hand, our reply report by our two valuers rebutted his response on all locations to the strategic location like the CIQ and hotels and so on. You know, Chia, if you live in Ampang, in Kuala Lumpur, no, Jalan Ampang is a long stretch of road, you know.
But yeah, all the way.
And you live at the poorer part of Ampang, you can see KLCC.
Okay.
Does that mean that area is a prime area? No. Similarly, in Penang, you can see Komta for many parts of Penang Island, you know. But it doesn't mean that area is a prime area. So, so you just cannot make an aspersion by looking at, oh, it can be seen. You can drive there in 10 minutes. Driving in 10 minutes doesn't make it prime. Yeah. And also he didn't add, if there was no road to get the road, to go to the area, you must go and make a big U-turn and to go to this town center. In court, he tried to create the impression that you can just go across. Actually, no. We produced another map and showed him to go to town, you have to go and make a big U-turn on the old road and main road and to get to town. So it's not as near as you think it is. So based on that, the issue here is the market value prepared by our valuer more accurate and appropriate compared to the JPPH valuation? And whether JPPH erred in valuing the land at a higher price of 100+ million ringgit, double the price of transaction. Yeah. Learned judge said, it is tried law. You can test the valuation officer's report if he had wrongly exercised discretion or contravened the law by acting in excess of the powers provided under the Stamp Act. Court said, no definition of market value. We will need to look at the principles that you rely on. Okay. And the principle is on Land Acquisition Act principle. Supreme Court have made this ruling. So during cross-examination, I asked the officer, did you apply land acquisition principle? He said, no, I don't have to apply. The moment he said that, I knew I'm going to strike in this case because he has made a fundamental error. Because the law says, the Supreme Court says, to determine market value for stamp duty purposes, you must look at Land Acquisition Act principles. Amongst other, it says, look at recent sales of land in the vicinity within 2 years. The comparables that the government valuer used were transactions made more than 5 years ago. That I argued and judge accepted as the first error by the land valuer. Okay, of course, this is the Land Acquisition Act. You see the parts that I've highlighted for you. The recent sales of land with similar characteristics. You see that or not, my friends? Funeral parlor, crematorium, abandoned mall, low-cost apartments are the characteristics that color the land where our client purchased. You must take them into account. And don't look at the sales 10 years, 5 years ago. Remember I said 2 years. You know why? The market was sluggish at the time. When market is sluggish, value goes down. You know what is the irony, my friends? The
What?
sluggish report was not done by me. It's the Jabatan Valuation itself issued a report to say that the market is sluggish in 2018 and the value of the Johor land was hit the most in Malaysia. Not my client saying that. His own HQ saying that. We showed it to him in court. Yet
Wow.
he didn't take that
Okay.
into account. His own report by his HQ. So we wanted to show that what he was doing is not right,
Yeah.
and whatever formula he was using was not in accordance with the Malaysian valuation standards. Then we showed the method we used. We said we use the comparison method. Court accepted that. And we said comparison method requires you to look at only these: price of recent sales, similar characteristics, situated within the same vicinity, and the last transaction within 2 years. Now, in Ng Fai In, the Supreme Court said, in determining valuation, it must be done within reasonable time, the market value, bona fide transaction, land acquired, the sale must be based on adjacent land, not land far away, and they must possess similar advantages. Okay? Judge said, after considering the evidence of PW1, PW2, our witnesses, and DW1, the valuer, government valuer, I am of the view that the omission of Jabatan Penilaian to acknowledge the unfavorable surroundings of the land was the evidence that was due consideration had not been given by Jabatan Penilaian to all relevant factors in arriving at the proper market value of the land.
Well, the judge is very categorical about the findings.
Very clear, you know,
Very clear.
and it's a very good judgment by judge. And I also said this. I asked the government valuer, sir, do you agree with me that Malaysians, Asians have an aversion to stay nearby cemetery? He said no. He said no, you know. When he said no for Malaysians and Asians, I asked him, would you agree with me that the Chinese have aversion to stay next to cemetery? He said, I don't know. Okay, I don't know. I then asked him, would you agree with me that assuming the Chinese have aversion and you don't get Chinese buyers, a quarter of the population are Chinese, and this is in urban areas with a more Chinese concentration of buyers, they wouldn't be attracted to buy the property, isn't it? He said, I don't know. I said, okay, all right. If you don't know, you don't know. Then I asked him this, you also agree with me that when it comes to purchasing power, economic purchasing power, the Chinese have better economic purchasing power to buy? He said, I also don't know. I wondered whether he was staying in Malaysia or not, because he didn't know all these things. I just kept quiet. I didn't want to do too much because Supreme Court have said, I don't need to know what he thinks, but the Supreme Court have said, buying land next to a Chinese cemetery is a negative factor.
Yeah.
So the officer may think otherwise, but the Supreme Court said, buying land next to a cemetery has a depressive effect on the value of the land.
Yeah.
That was my submission in closing to court. That he may say what he wants to say. He may say Malaysians are not bothered about buying land next to cemetery, but I got a precedent to say Supreme Court said nobody should buy land next to cemetery. In fact, I challenged whether the revenue got a opposite case to say or not. Malaysians are not bothered about cemetery. They are happy to buy land next to cemetery. Please lah. People don't want to buy land next to cemetery, funeral parlor, hospital, sewage pond. You know sewage pond? Inda water sewage pond. Those land are very, very low in value. Correct? Common sense. If you go to any housing estate, the houses surrounding a sewage plant are cheaper than every other house along the main road. Am I right? Common sense.
Yeah.
Yeah. Houses that may face adverse or negative area, the property is always cheaper than a property that is in a better favorable location. You can see that in the condominiums in Klang in Kuala Lumpur city center. Condominiums that face KLCC fetches a premium. The same development, the condo that doesn't look at KLCC is cheaper. That is realities of life, common sense. But this officer, it was irrelevant for him. But fortunately for me, the Supreme Court said all these factors, the close proximity, says if the IRB, if the custom, if the valuer doesn't take this into account, that means the valuation principles are flawed. Okay. So judge then said, although the land is not contiguous to the funeral parlor, cemetery, and crematorium, they were in close proximity, and by not taking into factor, the valuation is not consistent. What the officer said was, the land must be exactly next to it. In our case, there was another land in between, then the parlor. He said that is not negative already. I was wondering, I don't know where he got these feng shui elements from, you know.
I think maybe he meant the spirit cannot cross that piece of land.
Probably lah, you know. You know,
Boundary of the cemetery will be the limit for the ghost, for the spirit.
So you see, Chia, here the unreasonableness of the assessment was the value next to funeral parlor, crematorium, and cemetery is a package, lah, Chia.
Yeah. True.
You know, already next to one cemetery is bad. This one got 3 in around you, you know. But my client say he can still develop the land, but not high-end property. And he said the property will be sold at a lower price because the land is cheap. So they said they are first-time house owners, people who really want to buy a house, may disregard the cemetery and still buy the house.
Sure.
So, ladies and gentlemen, if you're listening to this webinar, we are not saying the land cannot be developed. The question here is, what is the value of the land and the consequential development? It will not be prime. So to go and value the land as if it is prime land, that is where was our complaint. Okay. Then after the oral evidence, the JPPH failed to acknowledge the unfavorable surroundings. So on that basis, the court said is a factor in our favor. Now, of course, the sluggish market, which our valuers considered and provided their expert opinion of the condition of the market value. They explained how it affects the market in their report. So you must get very good valuers who are very detailed to give a report. Yeah. Then they said the other thing was the credibility of the government valuer. Right? The person who prepared the report did not testify in court. It was someone else who was regurgitating the report in court. So when I pressed him, asked for more questions, he then explained that he didn't do the report. And judge said it's hearsay evidence. If a hearsay evidence is tendered in court, the court will not give weight to it. This is civil, not criminal law. You can't give hearsay evidence in civil court. Okay. So here, judge said the government valuer admitted he had no personal knowledge of the valuation and reply reports. He was merely a witness regurgitating the information. Although he attempted to explain and clarify the report, it was evident he had merely reiterated the statements contained. As such, the contents of the report remain hearsay, and it would be wholly unsafe to give any weight to them. Okay. So this is the question. This from the notes of proceedings. This is me asking the question to the officer. Kalau saya hendak tanyakan soalan, if I want to ask you a question on table of adjustment, Encik H would be the best person to testify, isn't it? He said yes. All the adjustment and so on was done by Mr. A, correct? He said yes. Not by you. He said yes. If he didn't explain why, you wouldn't know the answer, isn't it? He said, yeah, not sure. I said, not sure. You know, you don't know, right? He said, yeah, because this report is prepared by Mr. Hazimi. So the witness at the end said, when I asked him, no personal knowledge, he said, yes, I don't have personal knowledge. So judge then said, accepted in evidence and said, the witness had no personal knowledge of the matter. Even if reliance is prepared, all the tried principles are ignored, relevant factors are not considered. As such, the JPPH have erred in valuing the land at 107 million. So that is the first case on land valuation we did. So I got a lot of land valuation cases now. So you know what I do? I ask for the valuer to testify. I want to cross-examine. Stamp office objects. I say, I want to question him lah. Cannot. Look at affidavit. I said, no affidavit cannot. I want to put my valuers are going to testify. You don't want to call the valuer, it's your call. Remember evidence law, if you don't want to come and swear and allow your evidence to be tested, then the veracity of evidence cannot be, very high, So it is especially expert value apa mau takut kan, So that is
I
the
think
thing.
so. No, I think it's important to have some kind of a cross-examination of the maker of the JPPH report because they have the upper hand.
Yes.
In the sense that private valuers report comes second to the government valuers.
Yeah, Chia, he
spent
1.5 days.
Very important to challenge them.
He spent 1.5 days for cross-examination. Yeah. One whole Sunday was in court.
It's good practice now in the land acquisition matters in court rather than just based on affidavits and a cold hard fact of the documents without any cross-examination.
Yes.
It's a very good practice too.
Yes. The judge did tell me, why am I asking a lot of questions? I said, Judge, I got a lot of questions to establish. The burden is on me, right? So very fortunately, judge was very patient. So, before I go to Q&A, I'll do one more tax case. Rainforest, 2 families bought a residence, all valued. There's a tax avoidance issue, that revenue loss. They sold the properties to each other for 380 ringgit in 2002. Okay. IRB valued the land at 550 ringgit based on a 2005 valuation. Are you with me? So they got a government valuer to value the land at 550 ringgit in 2005. But we bought the land as transacted on the land in 2002 for 380 ringgit. So during cross-examination, Dr. Naban only had to ask the officer this question. Your valuation report is for which year? He said 2005. 2005. And I asked, and then we asked the next question, what year is the transaction year? He said 2002. So your report is not relevant at all, isn't it? Because you have valued the land on the wrong year. He said, yes. That's how we threw out his report. His report was irrelevant in court. You see? So, moral of the story is terms of the reference you give to the valuer is very important. Yeah, don't go and give the valuer wrong terms. If you do that, you will get a report like this, which is not relevant to the case, which will then allow a counsel to throw it out of court. Yeah, and here we went on to win the case, and the court ordered that the value of 380 ringgit was the arm's length price and allowed the taxpayers appeal. Okay, so I will not want to go into the effects of the tax avoidance issue. That will be another day for us to look at. But Rainforest is a case where the value was discussed. What I want to do now is, Chia, go back to the first slide I gave.
And the three key issues.
Exactly, Chia. And sum up before I take a lot of questions here. So I want to go into the questions straight away.
Yeah, the three questions.
So our webinar today wants to focus on these 3 questions. Whether JPPH valuation is final and conclusive, I think I've established that it is not. You can challenge it and bring in robust evidence to get caught, not to be persuaded by JPPH. And how do you do that? You then, that brings me to the third question, how to challenge the evaluation prepared. Make sure you study their report, find the weaknesses, do your own report, get two valuers, two reputable valuers who will say the report, how it should be looked at, and study them and then make a proper finding. Show all the irrelevant factors that they have considered. Show all the relevant factors they ignored. You must really zoom and dissect the report. Like any other expert report, you must spend time to study it. I spend time reading valuation principles, you know, to understand how valuation is to be done. So if the many lawyers are listening to this call, to our webinar today, and if you're asking me what's the secret is you must examine the valuation principles thoroughly. Read all the land acquisition cases on valuation in Malaysia and in India. Indian cases give you very, very good points. And finally, go and speak to the two experts I know in cross-examination, Rosri Dahlan for land acquisition, because land acquisition specialist, and Dr. Naban on how to push the witness down the cliff. There's the art of pushing it and putting your case to them. This is how you challenge them in great detail, right? So how...
And also the point that you mentioned, Sarah, just now, that although it's originating summons, usually by affidavit, you must also apply
call for witness. Exactly, Chia. Apply to call for cross-examination. You know, and take the effort to go and visit the land yourself. You must visit the land. Nothing defeats a personal check, you know, land. That's where I saw the mall abandoned, you know, and hey, I said, this is not right. The report is missing, you know. We attack that, yeah. And what are the factors to be considered in engaging our valuer? Please appoint a qualified valuer who's registered. Tell him exactly what is the issue at hand we have, and tell him he must be prepared to come to court to testify one day. He must defend his report in court. If he says, oh, I give you a report, but I won't come to court, then don't waste your time. Yeah, because you must get someone who will come to court and testify for you. Otherwise, what's the point of engaging the valuer?
Okay.
Because we want a valuer who will defend his report. And here we are very lucky at two good valuers, you know, from Johor Bahru, who are very, very sharp in doing it, you know, and they are very industrious. Every affidavit they reply, they do reply report, a table of adjustment, brief me, you know, they briefed me to make me understand land valuation, you know, because what I read in the books were academic, but because I was a studious student who have already read the principles, they helped me to the practical application of it. You see, so this is how I think these are the key questions we must consider when we want to challenge JPPH valuation, whether it's for land acquisition, whether it's for stamp duty, or for income tax purposes. So on that note, Chia, I think there are a lot of questions here. Please type your questions into the Q&A box.
There's a question answer, yeah.
Yeah, then I'll answer. Chia, there are some questions on income tax and all that, but you ask me questions on stamp duty first, then I answer the other questions.
Yes, on the stamp duty, there's one question by this person, this participant, Chia Loong Thye. Okay, Mr. Chia here, also, I think my relative somewhere. Hello, Mr. Chia Loong Thye. Hello. Anyway, the question is concerning the at what point of time you made the assessment on the stamp duty. If I can read the question, it says that in a case of transfer implementing a sale under a duly stamped agreement of the sale and purchase agreement, the date of execution of the agreement, or you should take the date of the transfer. In short, where there is a sale purchase agreement, for the purpose of assessing the value, you take the date of the sale purchase agreement, or you take the date of the memorandum of transfer. I think that's a
See, the
question
law is
asked
settled.
by-
If the SPA is stamped, you take the SPA date.
Okay.
That's my view. That in the law is settled on that point. Based on
Alright.
the cases I've done. If it's not stamped, then yes, we have a bit of a problem. But if it's stamped, you follow the stamp date.
So, Mr. Chia, the answer is that is based on the SPA date if there's a sale purchase agreement. If not, then you based on the transfer form. All right. Some related question on this stamp duty. Stamp duty is what they call the mode of payment, Sarah. That is to say that when there is an assessment made by the stamp office and you want to challenge it, you pay first or before you challenge it. You see, there are two levels of challenge. One is a notice of objection to the collector. And then the collector will decide, and if you don't agree, then you go to the High Court. The question asked by some people is that, do you have to pay first? In other words, is payment of the stamp duty, the disputed stamp duty, is a precondition for you to launch an attack.
Yes, yeah. Unfortunately, for Stamp Act, it's an old archaic act. You got to pay first before
Okay.
your matter goes to the High Court. Therefore, I tell my clients, please pay under protest. And in your prayer, like in the Parkwood case, I got interest at 8% from the date of payment until the date of refund. So you can pray for interest on this.
Okay, but what about if the sum is huge? You know, is there a possibility
No
of
choice, yeah.
seeking
No
a
choice,
stay?
yeah. The law is such. I don't see a law making an exception to that.
Then, what about a possibility asking for a stay then? Stay of
The thing is, how do you ask for a stay? Because for your application to go to High Court itself, your duty must be paid first, you know.
Hmm.
So what is your course of action to file for a stay?
So unlike the other situation, income tax situation, where you can ask for a stay, but in here,
Yeah,
you have to pay
you
first.
can't.
The law is worded differently.
No one has tested it, but if anybody wants me to test it, I'll go and test it for them.
Okay.
But
Is
as I
there
know,
a
you got to pay it first.
Pay first. So that means even the payment by installment is also not possible. Like you know, in the normal income tax situation, not a stamp duty act, where you can actually negotiate and pay the amount
Yeah.
assessed.
I have not come across installment payment for stamp duty as well, yeah.
All right.
Neither have I come across it.
So if I can ask one more question on this one related to this payment, where you pay under protest and then you go to the High Court and challenge it, and assuming you win in the High Court and you can seek a refund of the money or part of the money, because can you ask for interest?
Yes, yeah, you can.
On the
That's what I did in
SST?
this case. I asked for interest and I got interest, 8%.
8%.
From the date of
That's
payment.
fantastic. Is it the first case where they're going to appeal, right, against this decision?
Of course, they appeal. The revenue appeals in all the cases now.
Okay.
Yeah, there's a good question here, if I may read. What if the instrument falls between two items under the Stamp Act and there is a conflict or ambiguity?
Okay.
If there's a conflict or ambiguity in the taxing statute, whether it's taxable or not, the Supreme Court in the case of UMPC versus Peculiar Triangle said that it is like income tax. The taxing statute is to be construed what they call favorably in favor of the taxpayer. Yeah.
Oh, there's a presumption that is that it will
If
be in favor of
there is
taxpayer.
an ambiguity. But if it can fall under two items of stamp duty, the stamp office can, there's a presumption also, different case law from England. I can't remember the case offhand. They can choose to stamp you under the item that carries the highest amount of duty.
Okay.
Yeah, you remember that, yeah. So there's another question. What is the time limit for the collector to raise an assessment? There is no time limit for him per se under the Act. There is time limit for you to appeal, but there's no time limit for him to come back after adjudication, raise an assessment. We got a case now. They said they'll wait for Parkwood. When we have now won, they don't want to raise assessment yet. We want to go to court. But they
Yeah.
said you wait for Court of Appeal to decide. But most people will pay first, Chia, because you want your MOT to be executed, you see.
Correct.
Yeah, that's why.
Because,
So when-
because under MOT, there's also a time frame for you to file the MOT in the land office. It is 3
Yes.
months from the date of the transfer form.
Yeah,
Otherwise, we another set of penalty in late filing, because late registration of the transfer form.
yes,
So that's another set of problem faced by the taxpayer.
yes. So that is where we need to look at valuation from that angle. So unfortunately, it's a very very archaic area of the law. Hence why this area of the law hasn't evolved so much. So hopefully one day we can go and argue in Parliament, get Parliament to amend the laws. You don't have to pay first, you know. So you have answered all the interest questions and the stay questions. Installment also answered. Are land valuation principles under the Land Acquisition Act applicable in land valuation exercise for stamp duty purposes? Yes, as I said earlier, you must look at the land acquisition principles. Yeah.
Correct. But
There is
before you
a
can bring in your private valuer in to challenge the what I call the government valuer, you have to cross the hurdle first, right? That the
Yes.
government valuation is not up to the law.
Yes.
Comply with the law.
yes. Yeah,
So that
Chia Loong Thye has asked another question based on the case law they has read. He said the taxpayer entered into SPA in August 2018. However, the market value was only done by the valuers in 2019. Was there a typo? I said, no, there's no typo. When you enter the SPA, there's no market value report was done because I'm buying from a third party. That is the market price, right? Only when the stamp office said my value is not market value, which was 1 year later, that is the time where the client then will engage land valuers. You don't engage valuer each time you do a transaction, only when there's a dispute or the value, they go and employ the valuation. Chia. So I hope that clarifies.
there's one question relating to valuation is by Encik Nordin Daharom. The question is, the date of valuation is determined by the collector of the stamp duty. He asked, how do you challenge that? That's the date of valuation.
For RPGT purposes, you follow the SPA date. Because the government approval is only a condition to say the contract has been concluded. Is the SPA the value? My view will be the value.
But remember, you mentioned just now in the Rainforest case, the agreement between the two partners was in
2002.
2002.
That is the income tax case, Chia.
That's the income tax case. Okay.
Yeah. Then there's a question by Hui Ying. What is the approximate radius should be considered during the valuation to take place to justify the value of land? There is no one right answer way. Vicinity, depending where your land is and the size of your land, right? So if you are buying large estate land, land can be so big that you may not get anything in the nearby vicinity. It could be a bit further. But in the city area, I think all the surrounding land along the main road or the nearby area would be a factor to look at. So there's no hard and fast rule here. Yi Hing.
Yeah. This one,
We only have
real property gain.
Chia mentioned. Chia, they asked you a question, Chia.
Yeah.
Anonymous attendee. Chia mentioned JPPH valuation as an upper hand as compared to private valuation. What does he mean by that?
Yeah. Upper hand. That's related to the question that before you can bring in the private valuers, you really have to challenge the government valuers, because in a sense, there's a threshold you have to cross first, right?
Yeah. So that's the thing. So they may on the face of it be the valuer and they may rely on it. So that is the upper hand I think Chia was referring to, because the stamp office or even the land value, even the land office will rely on the JPPH value first. But that's where you don't challenge it. So the burden is on us to prove that it is wrong. The unfairness, I think, is this. JPPH is a department under the income tax, MOF. Income tax stamp office also under the MOF. You know, I'm not saying they're biased, but you know, perceivedness of being biased. In that way, I hope, you know, law will evolve and the valuation will no longer done by government. I think government shouldn't do valuation. The government must move on from that. Government should just focus on core administrative matters. Let the private valuers value it. You got land valuation boards and all those people, you know. So I think we must move away from the colonial mindset. Government valuer, you know, you shouldn't. You know, that's not how it should be. You see?
I guess it's still the very old mentality that
Very, very
government
archaic
revenue.
mentality.
Yeah, government revenue, therefore you need the government valuers to be on the
He's
side.
always correct. And guess what? Stamp office also is from there. One is the Abang, one is Ade. Cannot lie, you know, it's not healthy for investors to come and for them to be convinced with that. One attendee asked, what's the most difficult tactic used by IRB in court for similar valuation cases you have faced? And how did you overcome them? They will insist they are correct lah. Then you got to cross-examine them and show them that the answer they're giving in court is absurd and doesn't make sense. It defies logic. That is the only way you overcome them, my friend. Otherwise, very difficult. In cross-examination, you got to prove that the witness is not doing it correctly.
And that is where the difficulty. I mentioned earlier that a number of my lawyer friends based in Penang, we were discussing about it only yesterday, and the difficulty of challenging the valuation by the stamp office. And in their cases, but they've done 4 or 5 appeals against the decision. Only one of them only won. The rest of them, they lost the case, lost the appeal.
Yes.
So there's some questions on the income tax section 140. You want to take them now? No?
No, there's a lot of stamp duty questions, Cham. I'll take this question here.
Yeah.
I'll take it. Sometimes the consideration in transfer are so many factors by Nordin Daharum. Does not put to market value. How do you scrutinize the issue? Nordin, I think you're asking me there are many factors. That is where, Nordin, as a valuer, I would rely on a valuer to decide which are the relevant factors. And if there are certain factors which are not relevant, he needs to then in his report tell and why he dismisses them. So the report is very important, the way he prepares the report. So that is how I would look at it, you know.
Yeah.
Mr. Sarah, please let us know who are the 2 private valuers engaged. Since we know government valuer in JPPH is JP. You can look at a judgment. One is name of KGV and one is Landsurf. You can email me. I can give you the contact details if you want them for valuation. Okay. I is already reaching 3:30 already. I'll take the last 2 questions.
Here, there's one.
In practice, stamp office takes market value on land on MOT date. How do you counter the stamp office? Please bring section 12A to their attention.
Yeah.
Please bring section 12 capital A of the Stamp Act to their attention to tell them how the valuation is to be looked at.
There's one which is related to that, Sarah. In the past, the SPA for land transaction could be executed, but not the MOT. And if the MOT is only executed 10 years later or even 20 years later, will the stamp duty be calculated based on the market value of the SPA or market value on MOT? I think we answered that.
The question is, was the SPA stamped?
Yeah.
If it's not stamped, then the MOT value applies.
Yeah.
So it's in your benefit to go and get the SPA stamp. But if your transaction is an exemption transaction, irrelevant lah. Whether you stamp or don't stamp, whether they follow MOT or not, the fact is you enjoy exemption.
Right.
So it should be all right. But bear in mind, the IRB may come and say section 15A exemption is only for the SPA and not for the MOT. They did it in the case of City Tower, yeah. They said only the sale of business agreement is exempted from stamp duty, but not the MOT. So the agreement was $10. They wanted to give us a $10 exemption. But we argued and won the case in court. We said that is a very absurd way of looking at the exemption laws. Okay. JP,
Do you
IRB
have-
always ignore third-party valuers other than JPPH. How do you encounter this? Seems like all companies are encouraged to find JPPH for valuation. Any comments? I don't know whether private sector can go to JPPH for valuation or not.
I see.
I don't think so. I thought they only value for government agencies. I don't know whether they go to private sector for private sector or not.
I doubt so.
But what we call we went and they ignore because I guess they always get away. Very few taxpayers challenge them, so they think they have an upper hand there. Vanessa asked, what is the reason that the land office JPPH didn't call their person who prepared the report? Apparently he's retired, but he's only 40 years old. So that doesn't mean he cannot be subpoenaed. They could have subpoenaed him, you know. Nodin said, my opinion is not really back. He begs to differ. Even professional also follow the client instruction. What is your view? That is wrong, Nodin. We are professionals. A client can instruct us, but when we prepare our report, we have to decide and we must take ownership for it. In me doing my cases in court, I listen to my client's instruction, their suggestions, but end of the day, I am ultimately responsible for my case and my conduct and for my engagement in court. I was an expert witness before in Singapore last year at the Singapore High Court. I gave an opinion to the Singapore clients, which was produced in court. I have to decide myself whether it is right or not right. So as professionals, we must be very clear. We cannot let clients dictate to us how to do the report. You know, they can say what they wish, but ultimately it's our call.
Yeah, just related to that, Sarah, is where the need to have this cross-examination process. I mean, the government, the IRB people can cross-examine these professionals and to ascertain whether their professional view is biased or not, or they've done the proper job. So this is the usefulness of having cross-examination. It works
Yes.
both ways.
And final question, since the durian end of the durian season, Mr. Mark Kong asked, for agri land, JPPH valuation took into account the price of Musang King durian, where the trees are not mature. Can we challenge it? Of course, Mr. Mark. God knows what is the value of Musang King 10 years from now. You know, it's not right at all. Future value is irrelevant, you know. When I was a young boy, Chia, not too many years, about 15, 20 years ago, there was no such thing as Musang King. It was D24. Remember?
Yeah. Yes, that's right.
It was D durian to go buy and eat. Today, nobody wants to buy D24 anymore. It has become, you know, like a normal durian. So 10 years down the road, all we know, there might not be Musang King as the king anymore. There'll be some other durian variety, you see.
And the taste also
that is
changed.
Yeah, people change, our taste buds change. So I don't think it is right, Mark. Of course, you can challenge it to show it's completely irrelevant factor to be considered. Okay, I think that calls an end today because ours is a one-day session. So we call it a day, and some of the questions have been most of it have been answered. Some I didn't answer them because they came a bit too late, and we wanted to go to the earlier questions first. The slides will be made available to you. It'll be emailed to you by my office. So thank you very much, everyone. And there's another seminar I want to highlight to you all. Afika, please register and join us. Since everybody is so interested to know about public law in light of our political developments in Malaysia, we are being mature. We are a mature democracy now. So I want to share with you all this slide. It's complimentary. If you're a lawyer, you get a CPD point. Enlarge it, Fika. This is a public law series where we have 4 sessions. Each of the sessions will be spoken to by Justice Hishamuddin Yunus, together with our guest speakers, former Speaker of Parliament Tan Sri Arif, Justice Gopal Sriram, former Federal Court Judge and Lead Prosecutor for 1MDB, former Federal Court Judge Dato Prasad, and EC Chairman Professor Azmi Sharum, formerly a professor at UM. And we're very fortunate. Can you go up? On the 3rd of September, we'll have a royal address by the Negri ruler. He's also a law graduate, where His Royal Highness will address on the topic of discourse on the federal constitution and the importance of federal constitution in the exciting times that we are in now. So with that note, thank you very much and hope to see you at our next seminar soon. Thank you.
Thank you. Thanks,
Bye-bye.
Farah, and thanks everybody.
Bye-bye.
Have a good day.